opinion, the mistakes happen oftentimes because folks just don't appreciate how difficult it is and how serious the government is about getting every detail and getting it right.
Welcome to Simply Trade, brought to you by Global Training Center. My name is Lalo, and together with my co-host Andy, we have well over 60 years of combined trade, logistics, and supply chain experience. Along the way, we have seen and witnessed different challenges in trade compliance. We decided to put the show together and call on our friends and colleagues in the business to hang out with us and share their knowledge in all things trade. Thank you for spending some time with us. Enjoy the show. Recently, we've been talking about lots of like how to get the attention of your managers and your executive suite and all that kind of stuff so that they can listen to you on trade compliance. Michelle came to us with a really good idea on just pitfalls for export controls. I mean, things you don't think about.
That too.
Yeah, is things
Right.
you don't think about. So I mean, I don't know. I think this is going to be a good episode in the sense that it's going to shed some light on things that we normally may not think about or why. Anyway, I like the idea. So go ahead.
The level of detailed knowledge, Michelle, you have is phenomenal, and it's just like but you display such grace and wisdom when you're presenting things to people that I'm always in awe of you. And you're just one of my favorite folks that I love being around you, but I also love learning from you.
Thank you. You're too kind, Andy. And I love presenting with you as well. You always have something really interesting to say, some sort of an observation from experience that we can put into motion,
Yeah.
So.
Well, it's one of those where, again, some of these topics it's so complex and you can lose somebody real quick. And if you can keep me up there with you, because you know me, I'm dumb as a box of rocks is what I always say, and I got to keep up with you. And if I can understand it, then hopefully the rest of the crowd can, because I'm like, at that fourth grade level,
I think you're at least you're ahead of fourth. I'm sure you're ahead of fourth.
Oh my God. Well, listen. Okay.
You're awesome.
I love your topic. This is going to be one for advanced export compliance. So when we're saying advanced, it's like you've got your basics with your synchronizing your data, if you will, from your purchasing all the way through your compliance, your commodities are classified hopefully accurately, and all those kinds of things. That's your basic stuff. The information that you generate with your commercial invoice, some use letters of instruction, some use, with your bill of lading you're even creating. Hopefully you have synchronized your data with your bill of lading, regardless of mode of transportation. So synchronize the data with your bill of lading, your commercial invoice, and all the other data, so that really all the information should be on your paperwork up front, and that a broker, a transportation company really they should not have to go to a database, if you will, a computer, to look up any information. It should be right there. Now, okay, that's said, and that's easier said than done, right?
Yes.
But as we get into more advanced topics in this, is that now we're getting into some nitty-gritty things, and there has been an upscale in export controls, export accountability, if you will, from the U.S. government towards exporters and importers that are doing some things in transit and whatnot. All right, so Michelle, with the pitfalls, and again, I love the concept here, the pitfalls of advanced export compliance, why don't you just start off with where, in general, what you're going to talk to us today about and what these pitfalls are.
Sure. So, as you know, Andy and Lalo, I'm an international trade attorney, which means I typically don't get calls from companies that are doing everything correctly. In fact, I often get calls from companies that have made a mistake or potentially made a mistake. And so sometimes I feel like my whole career is problem solving and being a fixer for people's mistakes. But with that said, I also find that companies tend to underestimate both the government as far as how strictly they will enforce and the complexity of export issues. We have many cases where a company will call us up and they'll say, we don't export, but so-and-so told me to call you. Come to find out, we pull up their ACE data. They've been exporting millions, and they just didn't know that they met the definition of an export. So there's a lot to consider with exports, and in my opinion, the mistakes happen oftentimes because folks just don't appreciate how difficult it is and how serious the government is about getting every detail and getting it right.
Okay, let me talk about it before we get too far into some details here, is that in general, as far as the level of accountability towards the executive levels that the government is looking at for accountability, their own personal liability, as well as liability of the company, the executive levels, and I'm talking literally the CEO, Chief Operating Officer, even the CFO, have some really, they've got skin in the game in this, in that I've read recently there was a company that was trying to do business and send some information to Russia and China both, and they got themselves into not only trouble from their company, but they themselves were brought up on criminal charges for the actions that their company was trying to follow through on with a international transaction. Is that valid? Is that am I reading that correctly, that it comes into, this is what we're under the umbrella of the advanced export compliance?
Yes, absolutely. There are both criminal and civil penalties. And with criminal penalties, you are kind of looking at what you said, a C-level position, someone who is in top management. They'll want to make an example out of them. So, for example, if you had a sanctions violation or the Russia one you mentioned, it could be 20 years in prison. Now that's scary. You didn't kill somebody, you didn't rob somebody, but you did something shady with your export paperwork, and that can really land a person in prison. Also, monetary penalties. Penalties can be up to $1 million criminal, but even the civil penalties are now up around $330,000 per violation. And so the civil penalties are also high. You could make some errors that you don't think are a big deal, and come to find out the government views them as a very big deal, because export controls have to do with national security and regional stability and political issues. So a lot of stuff goes missed, and then you end up with these serious penalties and violations.
And in addition, then you've got a scenario where not only are you personally on the hook for some of the penalties as well as the possible criminal situation and all, but the company itself stands to lose its exporting privileges. And as such, I mean, if you have, let's say, 10, 20, 30% of your revenue is tied to export sales, and you can't export anymore, that would be, how would you like to be the executive of a company that goes back to the board and say, well, we kind of messed up here, and yes, it's under my watch, and oh, by the way, we can no longer sell internationally and export the goods directly ourselves. We will have to go through somebody else.
Yes, that could be, that could even sink a company, theoretically, if they don't get their act together, and we've seen that happen before. It's not the government's goal to cause trouble for companies and good business, but they will penalize And I think you reminded me, Andy, another thing that's really interesting about penalties and companies is they lose their reputation. At the BIS update conference, I don't know how many people went to that. There were a lot of people there. But this year, the Commerce Department announced that they were going to publicize administrative penalties. This is the first time. So you get named and called out, named and shamed.
Yep.
And that's just shocking to me from a PR perspective from companies.
Mm-hmm. Well, and that all said is, here's something else. Let's take it another step further. We've talked about the executive levels here a little bit and whatnot. And again, we're going to get in. There's a lot of good details that I like of the information that you'd sent in preparation here. But one of the things that we hadn't really hit on is the actual compliance management. The person, the director, the manager, the compliance person that is employed by a company. If you're involved in a company that gets called out on the carpet, if you will, like this, I mean, your own personal reputation is going to go, on the skids real quick. But the other thing is that what actions have you done as a compliance person to try and inform those above you and those around you? And the scenario there is it can be pretty serious for that particular person as well, would it not?
If a person is in a compliance position and they either don't know very much about compliance or they don't care, that can result in huge penalties for a company. So, actually from a legal perspective, sometimes when we see really big mistakes or what they call systemic problems, the company will let go that person because the person wasn't paying attention. So
right.
It can be taken really seriously because in the end it costs money.
Well, there's something that I'll bring up towards the end of this. As far as one of the things I like to do is we'll talk about the issues here, and I want to get into the pitfalls. And at the end of this is that, what is the key nugget of knowledge that somebody needs to take away from this? Well, some of these pitfalls are those nuggets that they need to pay attention to. But then the other is at the end of this is kind of recap and say, what is the specific action that a compliance-related person should be taking? The other thing is I want to be looking at it and go, okay, what are the specific actions or questions that a C-suite level should be taking to say, okay, we've got your attention now. What are the questions they should be asking of their internal organization so that, hey, am I covered? Are we covered? Or, those kinds of things. So we'll get into that in just a little bit here. So, all right, what's the first pitfall here that we can talk about?
So, first pitfall, let's say you're with a company that's about to buy another company.
Mm-hmm.
You probably have heard about successor liability. So with export controls, when you buy a company, you essentially buy their last 5 years of export activity. This is really frightening in a way because when mergers and acquisitions happen, we have usually corporate counsel, maybe some litigators, maybe some IP lawyers, but you're not going to often find that the trade lawyer is brought in until it's too late. So trade gets overlooked in mergers and acquisitions. And if you buy a company that has been exporting, or maybe they've been exporting and they didn't know it, the liability immediately becomes your baby. Go ahead, Andy.
Well, I was just going to say, is like, I have seen that situation. So again, for the audience, the mergers and acquisitions side of things, people are really they're moving quickly. They're trying to make a deal come through. Even those that coordinate those mergers and acquisitions, as you said, the compliance side of the thing is usually not what is not at the forefront. And so when people, I would say, that are looking at that, when you're forming your, acquisition team or your merger team, again, as you just said, there's the attorneys that are involved. There's, they're contracting the thing, the negotiations. That probably labor may be involved in some of this, and the marketing efforts and things of that nature go through. At some point, there's going to be accounting. Usually, it's part of the team, so they're going in, and you even may have forensic accounting that's going in and say, this is what was presented. Now, let's validate the information that has been presented in the merger. But one of the key essentials is that with the logistics, and I'm talking everything from the warehousing, the transportation, but also important is the export and import compliance pieces of it, not only U.S. but also globally. So those need to be added to those merger and acquisition teams as people are assessing things. And I would make sure that the compliance of the company that's being bought is participating along with the new owner, if you will, and their compliance team. Would you agree with that?
Yes, I do. And it's kind of like the Commerce Department and the State Department and NOFAC always say you have to have top-down support. So if you have key decision makers in a big business deal, they need to be focusing not only on the technical aspects of acquiring a company, they need to also look at, do I have liability here? For example, we've had some companies that have found out the company they're buying is probably about, I'm going to just say, $4 to $6 million deep in potential penalties. That company that's purchasing the other company would want to know that, because that reduces the value of the company they're buying drastically. And I think without top-down support, we run into mistakes because the people at the top are guiding the transaction.
Okay, so let's talk a little bit before we move on to the next point. Is that top-down support? Theoretically, it's easy to say, yes, the CEO or the COO, but I would say when it comes to this element, the C-suite is generally going to be pushing for this merger, or obviously they're making the deal, they're involved in the deal. More specifically, of that top management that should be looking at this is where the transportation, logistics, and compliance roll up to, whatever officer of that company is responsible for that. And it may be two different officers, because a lot of times the compliance group is many times under the legal umbrella. It could be under something else. A lot of times the compliance are going, it's like a stepchild. I don't want it, you take it, all right. But regardless, whatever officers we were talking about, top-down support, it should be whoever's responsible for that needs to step up on behalf of their organization. Would you agree?
I would agree completely. And tossing it around, that happens all the time. We see departments say, I don't want it. Or what if a department wants it, but they're not qualified to have it? That happens too. And you can bet that in an investigation of any kind, that a special agent would ask the question, what training have you had and what's your background? They'll call people and talk to them, and those folks may have no idea what an ACCN is, for example. And so it's really important that you have the right people and you have that top-down support centralized in some way with centralized records.
Okay, what's our next point?
So the next
pitfall
point is, this kind of spins off of the merger and acquisition question. Are you reading your agreements? The legal department in your company probably is reading them, but they're reading them with an eye to making a good deal, limiting liability. Do we want an arbitration clause? What's going to be the jurisdiction? Do I have to go to London to litigate this, or can I just stay here in Texas where I'm happy? There are so many things that those lawyers have to look at, so they don't necessarily have the time to look at contractual provisions that either protect a company or that harm a company.
Okay, so before you go further, let me just find. So when you're saying reading the agreements, agreements of what? A international, like the sale, like a buyer-seller agreement, or are you talking about the agreement of the actual merger itself?
Could be both. Typically, I end up reviewing what they call a master purchase agreement in an international sale. And
Okay.
the master purchase agreement, which they also call the MPA, tends to contain both buyer and seller side provisions. What the
Right.
seller will do in that type of agreement is say, okay, if you buy us, you hold us harmless for everything that we've done in the past 5 years. And of course, we certify that we've been compliant. The buyer, on the other hand,
Trust me, no problem. Yeah,
Yeah.
we're there.
no problem. We don't export. It's just Canada. I mean, we hear this all the time, right?
Yeah.
Or, oh, it's Mexico. Does that count? Well, it's still another
Yeah.
country. So, yeah, we'll find that sellers will make representations and then buyers will make representations. So, anytime that I'm involved in a merger or an acquisition, I have to first step back and say, okay, wait, first of all, who do I represent? Because if I represent the buyer, I'm going to rip up those sellers' representations. I'm going to make sure they're true. And I'm going to ask for sample records, sample export documents, and I'm going to audit. Whereas if I'm the seller, my main concern is, am I signing off on something that is a blatant lie? I don't know. I mean, the person signing the document probably has no idea whether a license was required for an export 3 years ago. So when you're the seller, you got to think about what you're signing.
All right, to that extent, though, is that I think we need to separate a little bit of the agreement of the actual acquisition / merger. Is one thing that should be reviewed and read by every single team member as appropriate. I mean, there's probably some things that can't be shared with everybody on that. That's for the C-suite level, I get. But I would think that the acquisition team should be reading the full contract. It may be, it's like, oh my gosh, let's watch grass grow because this is so boring, and then I'll fall asleep. But you got to do it, right?
Yeah.
Versus now, it would be a horrendous task, but it could be delegated down. But it's reading the sales or the purchase and sales agreements on your international transactions. That's going to be a lot of those, especially, I mean, you're sourcing out goods, you're selling goods, whatever. So I would think that needs to be a separate category, but equally as important, and has got to be reviewed for what you're looking for. And again, as you're going through those things, like you said, you got your seller positions, you got your buyer positions, and things of that nature that I find vitally important. There's certain language that you should be including in those contracts that if you're a U.S. party and it's you're selling, it's going to be crucial if you're dealing with a foreign entity to protect yourself.
Definitely. And you can imagine somebody signs something, or maybe you write a provision that says, I hereby certify that I have been compliant with all U.S. export laws and all U.S. export regulations for the past 5 years. Someone like me might come in and say, to the best of my knowledge and belief, because you want to do your due diligence and make sure that you haven't missed anything. But if something flew past me, I don't want to be held accountable for that.
Well, let's look at it this way. The difference of what you just said is like, all right, I have been compliant for the last 5 years for all U.S. laws and regulations on exports and whatnot. Okay, there's that. And then if there was an infraction that comes up, it's like, hey, wait a minute, did you just lie to us? Or you could be brought up and say, wait a minute, you certified that y'all were compliant, and yet here we have a problem. Versus you add that added language. You just said, to the best of my knowledge and ability. And there's like, you know what? I did not know about that. So I'm sorry, I was not knowledgeable of that. I gave you a truthful statement versus another one that could be considered, I certify it's correct, and it wasn't, and now I'm held liable for that.
Yes. Yeah, there's a lot to think about in there because even if the government holds the buyer liable and the government penalizes the buyer, there are certain remedies. The buyer could come back and sue the seller for breach of contract, for lying in the contract. So we have to look at the whole lifespan of this. If 3 years down the road they have a special agent knocking at their door, you can look back and see, okay, was this us or was this our predecessor?
Okay, so let me throw this out that comes to mind. Would you think it would be wise for people in executive level positions, whether they're an executive with a customs brokerage firm, a logistics firm, a manufacturer, a distribution firm, or something like that, a buyer, seller, whatever, you're going to have contracts that somehow your company is engaging itself in international transactions, or you may be facilitating the move and or entries thereof of your clients. Would you not think that as an executive or upper management of these said companies, that it would be wise to go, you know what, we're not buying or selling any, or we're not buying a company, we're not being bought out, but let me go and just look at our own contracts just as a standard rule and say, let me look at so many contracts a quarter or something, and just do a review and put your own team together. Would that not be a wise move, or would that be like overkill?
No, that would be wise. Even if you spot check, there are things like distribution agreements. There could be an agreement, even an employment agreement. What if you hire a foreign national and that person agrees that they don't need a license? Maybe it turns out they did need a license and they didn't tell you the truth about all their nationalities. So there are a lot of nuances there, and it can get tricky because there's certain questions you don't want to ask. And you can't
Joe's
ask.
a good guy. I mean, it's just like he's really sweet. I mean, it's like he told me he's good, right?
And he's so smart.
Yeah.
He's always really smart, and the company can't do without him. So,
But
yeah.
it holds you liable, though. Yeah. Okay. All right. Any more on your second point here is reviewing these contracts?
So I think on my second point, I would just say also that this does apply to every type of organization. It doesn't matter if you're a university. We can look back a few years and find the J. Reese Roth case where that university professor actually went to jail for sharing information with students. So it doesn't matter if you're a university, it doesn't matter if you're a nonprofit. Maybe you're saving the world. You still can't export stuff that might hurt the United States without a license anyway.
Right.
So I think that's something that also gets missed.
Okay. And before we go too much further, this is like kind of on the side note, but for those when we're talking about, well, it requires a license. What's a license going to do? Is it more of the extra bureaucracy that would be tied to the commodity, that if I have to file for a license, it's going to make my company, it forces us to become more aware of what really we have to do and where that's going, and that we're going to control where that product goes? Or is it just a bureaucratic thing for the government to charge me an extra fee?
It is definitely not about the fees. License applications, generally speaking, do not have fees to the government. You may have one to someone who's preparing the license application for you, but
Right.
you're not going to have a fee that you're paying to the government. What they do is they're going to ask you all about your product, everyone in the chain of command, who's going to control this thing, where's it going to end up, and they want to know that this is safe to ship. So
Right.
the license says either yes, we trust you, you can ship this, or no, we think this is a terrible idea.
Okay.
So yeah, it's permission.
Right. And like I said, it to go through that process to show the due diligence as appropriate, it's something that company, there's going to be some parties in the company that will gain firsthand knowledge of that particular product and that transaction, and will be held accountable for it. So it's like you have a responsibility to make sure that product goes out and it's licensed, and especially if it comes back in, it's all tied in with the same declaration to the government. So okay.
Yeah.
Next point.
Yeah,
Oh,
so licensing, that's I'll just throw in that licensing is another area where we see a lot of mistakes. Not only do you have to use the proper form, but this is not like fourth grade going in, filling out a form, and you're done. There's a form, but what you're doing is making an argument to the government that you can export. So if you forget any minute detail, like maybe you forgot to mention that your product is flammable, I don't know, I'm making this up, but it needs to be really detailed. And so licenses are another area where we see a lot of pitfalls.
Okay, to that extent, I will say before we go on to the next one is it would be, I think, wise that if you have products in your company that do require licenses, and there's different types of licenses and things of that nature as you're looking at it, but I would highly recommend, and see if you agree, that you charge somebody within your organization to become a first-hand, top-level expert on a specific license and all the commodities thereof that are tied in around that particular license. Would that not be a smart move?
Oh yes, that would be a great idea, especially if you plan to continue working in the same products in the future or the same types of transactions. You're going to have repeat licenses, and it would be great to have someone who knows what they're doing that you can count on every time to file the correct license application. We've seen instances where somebody just gets assigned a license application, they write a little letter, and they completely forget about the form. This can happen. There's so many areas where they can make a mistake. So I like the idea of having one designated person or more than one.
Well, and it also comes back to, there are companies that, especially if they're large ones, that have established a transportation council, a logistics council, something to that effect. To me, this would be an ideal scenario to where the compliance needs to be part of that. So if you're an executive level and you have these organizations under you, purchasing being one, or sourcing, purchasing, sourcing, I consider the same, it should be participating, but along with the transportation, the logistics as far as warehousing, the compliance, and all those things, that should be part of that council. And so that when something comes up and says, okay, we're going to review, we've got a situation here where we've got now product that is coming from Hong Kong. Well, with the scenario between mainland China now and Hong Kong and the scenarios there have been regulations that have changed. It's not the Hong Kong of days gone by. So can we still just do what we have always done? Well, the compliance side of things needs to look at it and go, oh, wait a minute, no, we've got some changes here, and I may not have all the answers right now, but let me take this scenario, don't do anything yet on it, let us have a chance to pull in the trade lawyers if needed, or the regulation side of things, and review that and see if this transaction now needs to be modified in some way, or can we even do it legally.
Great point. Yes. China and Hong Kong are a perfect example, because we have even run into Commerce Department decisions where if they think something's going into a military end item, they're going to stop it between Hong Kong and China, because, as I said earlier, you can't underestimate their intelligence. They know what they're looking for. They know when they see certain things. Okay, Hong Kong, China.
It's like we've always sold it to Hong Kong, and there's never been a problem. Now, why now? It was like, well, life has changed it for you over there. It's a different ballgame. Same thing with going to selling to Russia. Russia's now all of a sudden on some sanction lists and things have really dramatically changed. I actually had a client that I've talked with that it was a trading company, and they had offices in Russia, in China, here in the U.S., and Brazil, and different places. And I'm like, boy, howdy, guys, you what are you doing with some of these deals you're making? It's are you selling stuff or moving stuff through these other offices in these in China and Russia now? Because it's now you've opened yourself up considerably to end use violations.
Yes, absolutely. And Russia's a really tricky area, in my opinion, because you may find that, okay, the person's not listed, or maybe it's not a prohibited product, it's not a prohibited company. How are you going to get paid for it? The banks are prohibited for the most part. So you could try some kind of circuitous, sneaky route, but I guarantee somebody's tried that before, and you're not going to get that past the government.
That's what I call a scorpion type transaction. You may think you're doing fine, and then that tail comes back and nails you. So it's like, yeah.
Yes. So any kind of like transshipment, or I'm just going to ship it over here first, and then don't think that they haven't seen that.
Well, and it's like, hey, I sold it to somebody in XYZ company or country, and I didn't know they were going to take it and send it on. Well, you know what? You didn't show due diligence in the way you went about things. All right, so third point. What's the third pitfall?
Okay, third point is technology. Technology is I'm going to call it a cesspool for violations. Technology is something that just makes people shake in their boots, because technology is oftentimes intangible. You can't see it. It's hard to understand. And companies are dealing in technology all the time. And all you have to do to export it is say, put it in the wrong folder where another country of your employees can access it, or send an email. Foldering is something that I find fascinating, because folks may think they have everything in their folders, and then you have restrictions on the folders. But do you know who's working at every plant? It can get really tricky. Also, with technology, the area of encryption frightens a lot of people, because encryption has a different part in the regulations. Encryption is not so much asking permission to export, but it's telling the U.S. government what you're exporting. What are you sharing? The government wants to know, so that they know what types of encryption is out there. So
when we're talking encryption, are you talking about sending a computer with an encrypted hard drive, or are you talking about emailing a file or transmitting some kind of a file that's encrypted to a foreign source?
I'm talking primarily about sharing. I think your first example is perfect. Somebody maybe travels with a laptop, and that laptop has a certain level of encryption embedded in it. Then you have just exported that encryption, not just the laptop. And if the encryption reaches certain levels, it's going to require either a license or a formal classification from the government, or it may just require an annual report. But
okay, wait a minute. I'm sorry. Here, I'm getting confused here. So we're like, you may have to draw. You're gonna have to draw me a picture here. Okay, so here I'm gonna hit you a question. Is it the encryption or is it the data? When you're saying the encryption hits a certain level, I'm thinking it's more of the data in that file that may be involved in, let's say, the fan, the engineering specs on a fan of a jet engine that would be the content, and that fan in that particular jet engine, let's say it's on a fighter jet. So if that file is on the laptop or whatever, but you're saying, and it's, hey, we're going to encrypt it. Encryption is to keep it safe so somebody can't decode it and without the source code, not the code, what is the key? All right. But is that what you're talking about? Is that it's the content of the file, not the encryption itself, or is it the encryption itself? I'm a little confused there.
I'll get even more confusing and say both.
Okay.
So you're worried about the content because that could be controlled technology. And that content, that substantive content, might require a license or approval for export. There are certain exceptions whereby a company could use, say, a VPN, and if it meets a government standard that they call FIPS 140-2, that's considered high enough that it can travel from one company employee to another. But there's a second aspect of this. Encryption itself also has a completely separate part in the regulations. And that's more of a reporting than an asking permission. That's where, let's say I have some really brilliant new source code, and I'm going to share it with a foreign national employee who is a programmer who understands everything about software. I need to know if I can share that encryption technology with that foreign party, because for one thing, foreign governments may be trying to take that technology. They may be trying to use it. Also, we may need to hack it. I don't know. But remember the Apple thing where
yes.
The
information was on an iPhone, and Apple didn't want to. Right.
Yeah.
They didn't want to. All right. For those, again, it was a case where there was a criminal situation where somebody had their iPhone, and it was stored on there. The way the Apple was, it was encrypted in such a way that it was making it extremely difficult to, if you will, hack the phone to gain the information on, hopefully, foiling some kind of terrorist plot, if I'm not mistaken. But the whole issue was Apple was not willing to decode the phone. Do I have that one right? Is that what you? Okay.
Yes.
Well, I guess normally my memory is as long as a turtle's tail, but this time I got that one. Okay.
That's a great memory, Andy.
Hey, I'm good on this one today. I've had my medicine. Okay.
Yeah, Andy's had his meds.
So with that, that example you were talking about. So where were we going? Is that type of encryption? Is that requiring a license? You were saying or something?
So I guess what I'm saying is with that type of encryption, you saw a real life case where the U.S. government needed to know how to hack those phones and apparently couldn't do it.
Right.
If we are not the country that's the foremost, the best in encryption technology and hacking, what are we going to do when someone outsmarts us and they've got some plot and it's encrypted? This is exactly why they need to know what encryption levels are out there and what types of encryption different companies are using.
So that type of encryption, so the point being is in the encryption itself could require the license, and so that it's knowing, so that somebody may deviously try and get their hands on that type of technology of that source code to be able to hack into other files that are using the same encryption. So that's what the intent behind a license of the encryption methodology versus the content of the file. I get that. Okay.
Yeah.
I can learn. I'm getting there. It's like I just learned something.
And this is one of the most, if not the most, complex areas of export control that you can get to. It's confusing for a reason. It's not you. It's it really, really is difficult, and you have to be able to, in your mind, picture. Okay, there's technical data, there's drawings and blueprints, but there's also information that the government just needs to know, because we need to be out front, and we need to be the leaders in that.
Okay. Well, all right, good. Now, the scenario that I'm hearing and what comes to mind, back to what one of the actions that I had just mentioned, was having somebody becoming an expert regarding licensing. Well, equally as well, and it could be the same person, or again, you diversify this, and it may be somebody with more of an IT background, but the encryption methodology, having somebody become having a high level of expertise with the different encryption methodologies your company may be employing. But also joined at the hip is then, if you're going to send anybody internationally on a trip, just even a vacation, I would think it comes into play. If you're taking your laptop with you, or if you're taking your files with you, whatever the case is, or you're selling things, that they are joined at the hip with compliance, so that, hey, yeah, you're going to be covered. Not only the content, the methodology of encryption, they do or do not require licensing, but you have your own internal experts that should say, you know what, we need further counsel on this, but at least they have enough knowledge to point you in the right direction or ask the right questions.
Yes, exactly right. You've got to have the people who understand the technology working together with the people who understand the rules, and that information needs to be shared. So that's why you'll see a lot of times engineers dealing with trade compliance, and maybe they're talking also to HR. I mean, there's so many different areas where technology can touch, and a release of technology is an export.
Okay. Well, we need to wrap up. I as always, I could always just talk for so long with you. You are so fantastic. I just love it.
Thank you.
But we probably need to do a recap here of what we've learned thus far. So we've talked about with a merger and acquisition situation. Talked about in looking at that, you have liabilities for the last 5 years of that company you are acquiring, of their export, actually, quite frankly, their export and import activities, but I mean the export especially. Secondly, look at the agreements, specifically the merger acquisition agreement, as well as the sale transactions agreements, and any other type of contracts that you have that deal with international entities, correct?
Correct.
And then thirdly here is in looking at the licensing requirements of commodities, of technology, and encryption methodologies and things of that nature. Have I got it so far?
Oh, you've got it. And you can wrap all that up with a nice little bow with a technology control plan and an export manual.
There
That's
we go.
where all that will feed into, and you can have your company's rules designed to fit your situation.
All right. Well, and so with that, there's a lot of actions that we've talked through, and with that, the one thing I guess I will say is that we have, for the audience here, folks, we've just barely really scratched the surface. We've been talking about this a little bit, and it is easy to stay at the 50,000 foot level, maybe come down to 30,000 feet, and you get a little bit more details. But if you're in charge of a company or higher up in there, or you're in the compliance arena, there's a lot of actions, hopefully, that we've sparked your knowledge, your mind to think through and say, I got to gain more knowledge and take a little bit of action. You don't have to, swallow this all at one time. You got to take steps towards coming up with something. But I love what Michelle, that coming up with, what'd you call it, a technology protection plan?
Technology control plan, or TCP.
Control plan, okay.
Mm-hmm.
All right. So that's something that on the surface sounds very impressive, and I'm sure in doing it and pulling that together is not just something you just sit down and say, oh, let me just write this out a little bit. That's going to take involvement from a lot of different entities of your company.
Yes, and it will require good communication, but having that will go a very long way in protecting the company. If nothing else, having a short technology control plan, anything in place is better than having zero effort to control technology.
And then your export compliance plan is in reviewing things and how are you going to control things. And there needs to be probably several sections on that. It's we're not going to solve them all here, but I mean, including not only your technology piece, your sales transactions, but then also the employees, who you're doing business with, and are they, a foreign national, or are they a contracted foreign entity, and those kinds of things. So there's a lot there. So with all of that, we're going to be posting your contact information with our show notes, so that somebody can reach out to you and just maybe you can give you a call, just ask a question. You can point them in the right direction, or they may want to engage with you. But there's a lot of folks out there that could probably supply a lot of support for companies in a lot of different venues.
I'd be happy to help. I get so excited about this topic. If you have a good question, I'm all ears.
There you go.
So, thank you.
So Michelle, we like to wrap up sometimes with, like Andy had said earlier, we like to wrap up with how would you bundle or wrap all of this up in 1 minute or less? A good tip. I mean, it sounds like you did it already. You'd said the TCP and the export manual. So how would you summarize that in a minute? Like, what is the hack or the tip or the best practice that you would like to say, just to wrap this whole show up with?
I would say the tip is be aware. Be aware of the complexity of export controls, because it flows into contracts and big deals you're doing. It flows into technology, encryption, and even an employee's laptop. That awareness is what's going to make you ask the right questions. So I would just say be aware that export controls is a minefield, and that's something that companies often miss.
Right.
Excellent.
Thanks. Thank you so
much. All right,
much.
Michelle, I got to tell you, it's just, we have enjoyed you today. This is, once again, you're just fantastic. I just love you. You're just,
me
great.
too. I love talking to you, Wendy. I could talk to you all day. And now I know Lalo a little better, so I'm going to talk to Lalo all day too.
Oh, listen, Lalo has been a godsend in this. Is that he's been so fantastic in pulling everything together and trying to organize everything, and so I get to flap my gums here a little bit, and we have a good time. So.
Thank you guys so much for having me.
Thank you. It's
an awesome podcast.
Thank you very much for joining us. Simply Trade is brought to you by the generous contributions of Global Training Center. You can follow the show and GTC on LinkedIn or Twitter and other social networks. Make sure you check out the show notes in the description for a full rundown of today's show with all the important links. Also, make sure that you share this with a friend and subscribe on your favorite streaming platform. We really like hearing from you. If you enjoyed the show, make sure to rate and review wherever you listen to this podcast. If you or someone you know would like to be a guest in the show, or would like to sponsor Simply Trade, or suggest any topic you would like for us to discuss, please contact us via email at simplytrade@globaltrainingcenter.com, or you can DM us on Twitter at simplytradepod. Thank you again for the privilege of your time. Happy trading.